next case for discussion is the Reliance Petrochemicals versus proprietors of Indian Express. In this matter, it so arose that Reliance Petrochemicals had taken the consent of then controller of securities for the issue of compulsory convertible debentures. It so happened that this particular consent that was given by the controller of capital issues and securities was actually doubted by the media. Reliance was successful in getting an injunction against all these media personnel from making any publication onto the questions of the validity of the order passed by the controller. However, that did not stop the media from publishing information about the debenture issues. Challenging the particular actions of the media personnel, Reliance Petrochemicals questioned it to be something that affected the contempt of court, as the order of the court had given across a prohibition from disseminating information on the validity of these issues. It is pertinent to note here that the court took in close scrutiny of the articles that were published in the newspapers. It was opined by the court that the articles published did not pertain to the validity of the order passed by the controller, but rather had given information about the issues of debentures to the public. It was observed that the stoppage of these newspaper articles would affect the public interest, and it would be uncalled for and contrary to the freedom of press enshrined in the Constitution. It was further opined that the public had a right to know about the issue of debentures, as it was a matter of public concern, and the newspapers had an obligation to inform. As such, the said article was allowed to be published on strict terms. The court held conclusively that the right to know is a basic right which the citizens of a free country aspire in the broader horizons of the right to live in this age in our land under Article 21 of the Constitution. As such, the right to know becomes an integral part of the fundamental rights guaranteed under Part 3 of the Constitution. The next case pertains to Union of India versus Association for Democratic Reforms and another. In this matter, a petition was filed by the petitioner, which was an association, wherein they had sought to make the electoral process fair, transparent, and equitable. It was the contention of the petitioner that the recommendations of the Law Commission in its 170th report were to be made mandatory for us to ensure a free and fair election. The Delhi High Court had mandated that the recommendations be fulfilled. However, on appeal, in a bid to challenge the order of the Delhi High Court, the matter arose before the Supreme Court. Amidst dire arguments, the Supreme Court of India upheld the High Court's order mandating that the Election Commission is required to obtain and disclose the public background information relating to the candidates who were standing for elections, including the information on their assets, their criminal records, and educational background, all of which was necessary for the public to have a free dissemination of information about whom they would be exercising the right to vote. It is in light of the fact that having information about the candidates that they're voting would give the opportunity to the public to make an informed decision was the sole genesis of the decision. It was observed by the court that the citizens have a right to know about public functionaries, which is derived from the concept of the freedom of speech and expression, and which is inherent, includes the right to know about the background of the candidates for a public office. It was further opined that the right to know is a right derived from the right to freedom of speech and expression. The public has a right to know about the candidates contesting elections because such rights include the right to hold opinions and acquire information as to be sufficiently informed in forming and disseminating those opinions through election process. The court advanced this point by observing that a successful democracy strives towards an aware citizenry, and misinformation or non-information of any kind will create an uninformed citizenry which makes democracy a farce. Following the decision of the Supreme Court in Union of India versus Association of Democratic Reforms, it was felt necessary that there is a requirement for a change in the 1951 legislation or the Representation of People's Act. Consequently, few sections were introduced, such as section 33A, 33B, so as to allow for dissemination of information. It was provided under section 33B that the candidate is required to furnish information only that is required as per the Representation of People's Act of 1951 and its rules. It so happened that the very content of the section 33B became a matter of challenge in the People's Union of Civil Liberties versus Union of India. In this case, the petitioners challenged the validity of section 33B of the Representation of People Act of 1951, wherein it provided that, notwithstanding a judgment or order of the court or the election commission, an electoral candidate is not bound to disclose any information apart from what is required under the Act. This decision is pertinent to understand as to the scope of right to information of every citizen. To what extent can the right to know of a citizen be allowed for is a particular matter that arose as a contention in this court. It was observed by the court that a liberal approach to disclosure of information about an electoral candidate, although desirable, but the same compulsion to a person to disclose personal information would affect such person's privacy. It is pertinent to draw a line between the voter's right and the candidate's privacy. The legislature should apply its mind and lay down a criteria as to what information must be disclosed. The judgment of the Supreme Court in Union of India was to apply as long as the legislatures had applied their mind and created this criteria. The criteria being set in section 33A allows for disclosure of the criminal background and the assets and liabilities of their spouses and children, but however does not allow for disclosure of the educational qualifications of the person. On these facets, the court struck down section 33B of the Representation of People Act 1951, stating that the possibility of nullifying a judicial order or judgment requiring disclosure of information is something that should be held as unconstitutional. And secondly, the right to information, being a dynamic right, should not be curtailed but rather should be grown. It also further held, as stated earlier, that it did not allow for disclosure of information on the criminal background of the candidates and the assets and liabilities of the spouses and children. So as such, non-providing of the educational qualifications, it cannot be said to be violative of their fundamental right to freedom of speech and expression. So as such, it is pertinent to understand that the privacy precedes over the right to know of an individual. So right to privacy vis-a-vis the right to freedom of speech and expression, which inculcates the right to information, are aspects that would have a conundrum. With the discussion of these above cases, we have understood as to how the judicial exposition on the matter of the right to information and how the judiciary has shaped the right, wherein it was non-existential by an act of the legislature. One may wonder as to what is the necessity of discussion of these judicial expositions. It is to be noted that Article 141 of the Constitution of India provides that law declared by the Supreme Court to binding on all courts which are subordinate to it. This is a matter which is covered under the law of precedents. So as such, whatever judgment or order that is passed by the Supreme Court becomes the law of the land. As such, right to information was a right that was pre-existential to its legislative form by way of judicial decisions.